Ranchos.
I think it's funny how this project started because it came from them. That's, you know, they were aware of what we're doing, and I guess it really sets a precedent for our process, and I just don't really feel it's appropriate. We're very close. What we considered is minimal to bring it back, and I think that would be the most efficient way, and it's going to go to the board anyway. So I just won't be supporting the motion. Sorry.
Great. And so, Mr. Villalobos, if you read do the roll call vote, thank you.
Commissioner Park.
Aye.
Commissioner Cooney.
Aye.
Commissioner Farini.
Aye.
Commissioner Brown.
No.
And Chair Blau.
Aye.
Motion passes 4-1.
Great, thank you. All right, is that the projection report? Are we done with that?
So, Chair Blau, just to finish the projection report is the next, the October 31st, there are 3 items listed on that agenda, and then we have scheduled the return of the process improvement workshop on that date, and then we just take action for November 7th. There is the Koyama, it will be in Santa Barbara. So there's the Koyama Solar project, as well as the hoop structures will come back on the 7th. And after that, there isn't anything scheduled or projected until December 5th. So
okay.
that concludes the projection report.
Okay, great. That might be premature to cancel the November 14th meeting, but likely that might occur. Okay. Commissioner Brown.
Mr. Wilson, is there, in your own projected agenda, is there is the schedule pretty light such that you really don't anticipate anything coming by the end of the year for some of these meetings? I'm just trying to get a sense of, because it looks like we're not that busy. And
Chair Blau, Commissioner Brown, I think at this point it is a little premature to cancel any of those meetings. I think working with staff, there could be items that will show up in November on that projection report.
Okay, good, thank you.
Okay, that being the case, this is the time at the meeting where we allow for public comment for any item not on today's agenda. So, Commissioner Park, do we have any slips for that? No, we don't. I see no one rising. Next item would be the Planning Commissioner's informational reports. I'm not seeing any lights go on. So we have the minutes of September 12th to be approved. Any comments or corrections?
Pending comments, I move for approval.
I'll second.
Great. So all those in favor say aye.
Aye.
Aye. Opposed? No. Okay. Ms. Black, we have the director's report.
Yes, Mr. Chair and members of the commission. Since your last meeting, the board met once on September 18th, and we didn't have any departmental items on that hearing, and we just had one minor issue with a time extension for a Coastal Resource Enhancement Fund grant. But other than that, nothing on September 8th and 18th, and don't think I have anything else to report today, except on a few upcoming board hearings. So on October 9th, the board will be hearing the Ag Employee Dwelling Unit Ordinance. And then on October 16th, the board will be considering the Gaviota Coast Plan and the suggested modifications from the Coastal Commission. So they may be taking final action on that plan one way or the other on the 16th. And for some reason, it seemed like there was something else on that day, but I can't remember what it is. And coastal resiliency will go to the board. It's projected to go to the board on November 6th. So that's what's kind of upcoming, just for your commission's information.
Thank you. Commissioner Cooney, did you have a question?
I didn't.
Okay. Light again. All right, I think we're ready for our first item on the standard agenda. Mr. Villalobos, if you'll read it into the record, please.
Yes, thank you, Mr. Chair. The following is the hearing on a request of Jeremy Layton, agent for the DANS Network, LLC, to consider case number 18 CUP 9, application filed on June 14, 2018, and to determine the project is exempt from the provisions of CEQA pursuant to State CEQA Guideline Section 15301.
Thank you. And now I'll ask for ex parte and site visits. Commissioner Brown.
Several months ago, I got a call from someone, and I am not sure who that was, but we did discuss the project. And it may be the person who wrote one of the letters. I'm not really sure. But I live near Magnolia Shopping Center. I frequent it often. I like it. There's been some new ownership, lots of improvements, lots of vacant stores. So it's nice to see something coming to fill up the shopping center.
Thank you. Commissioner Park.
In reading the comment letters, I recognized one name as being an employee of mine, and so I asked her yesterday what kind of dance she did at the dance studio.
That's great. Okay. So, Ms. Montano, are you going to do our staff report this morning?
Yes, thank you, Mr.
Thank
Chair.
you.
Good morning, Mr. Chair, members of the Commission. My name is Ray, planner for items 1 and 2 of today's agenda. I will now be presenting the proposal for the Magnolia Shopping Center Dance School, conditional use permit. This is an aerial view of the proposed project site. As you can see, Hollister Avenue is located south of the site. Patterson Avenue is located approximately half of a mile west of the site, and the 101 freeway is about half a mile north of the site. Adjacent uses to the north, west, and south are residential, and to the east are residential with 1 recreational space. The subject lease space is in the easternmost structure of the shopping center, as shown here where the star is located. This map shows the zoning of the proposed project site. The site is located within the shopping center zone district, and adjacent zoning is primarily residential, with 1 recreational space to the east of the site. This is a close-up view of the 3,600 square foot subject lease space. The proposal includes interior alterations to the existing lease area, including the creation of 3 separate classrooms, 2 restrooms, and an office. The project also includes the addition of sound insulating drywall for sound dampening purposes. With the exception of signage, which would be permitted under a separate permit, the exterior appearance of the structure would remain the same. The proposed project complies with the Land Use and Development Code. Schools, business, professional, or trade, and more specifically a dance school, is an allowed use within the shopping center zone district. The project would comply with the shopping center zone's parking requirements, which requires 1 parking space for every 200 square feet for uses which do not require a conditional use permit. For a school that requires a conditional use permit, the Land Use Code requires 1 space per 5 students and 1 space per 3 employees. So for this proposed dance school, they would have a maximum of 20 students and 3 employees at a given time. Therefore, the dance school is required to have a minimum of 5 parking spaces, and the entire shopping center would be required to have 569 spaces. The shopping center currently has 576 spaces, so there is adequate parking. The project would also comply with the development standard regarding enclosure of activities, as the dance school would operate completely within the 3,600 square foot lease area. The project is consistent with the comprehensive plan, the Eastern Goleta Valley Community Plan, and the revised development plan for the whole shopping center, which was approved in 2001. CEQA Guideline Section 15301 applies to projects involving the operation, repair, maintenance, permitting, leasing, licensing, or minor alterations of existing structures. For this project, a notice of exemption was prepared. Staff concluded that there would be no significant environmental effects, no significant cumulative impact, and no mitigation measures are necessary. Staff recommends that your commission make the required findings for approval of the project specified in Attachment A of the staff report, including CEQA findings. Determine the project exempt from CEQA pursuant to CEQA Guidelines Section 15301, and approve the project 18 CUP 9, subject to the conditions included as Attachment B. This concludes my presentation for the dance school. I'm happy to answer any questions you may have. The applicant is present as well to answer your questions.
Thank you. Any questions from the commissioners? Commissioner Brown.
Thank you. I do have questions of the applicant, but for Ms. Montagna, the question is about construction hours. I notice 8 to 5. Is that for the Eastern Toledo Valley Community Plan standards, or is that usually it's 7 to 4? What?
Mr. Chair, Commissioner Brown, I did double check, and for the community plan, it's 8 to 5.
Okay, good. All right, thank you.
Thank you. Although, are all the construction activities within the inside of the building? So for me, that seems to be an inappropriate condition. There shouldn't be any. I mean, I can't imagine any noise that's going to occur if all the activities are inside the building. But
Yeah, Mr. Chair, I think it was just to be safe, but you're correct. All the modifications are for the interior of the structure.
yeah, 'cause I know even in the countywide projects, and I'm doing one now that my construction hours are limited, but they're not limited on the inside of the building, only to the outside of the building for tractors and things like that. I'd hate to get that confused. Commissioner Park.
Well, I was thinking the same thing. And so is this something we can change, even though it's in the plan? I mean, construction guys are going to want to travel to the site at 7 instead of 8. So
I think what we can do is we can talk about exterior construction activities would be the 8 to 5, but that does not apply to the inside construction activities. If
Yeah.
we could maybe make that modification to the conditions, it'd make me happy. I'd like to be
Yeah, Mr. Chair, we can make that modification to condition 4.
Great, thank you. So we'll hear from the applicant now. Does the applicant want to address the commission? I should ask the question.
Good morning. My name is Julio Jenner. Is this on? My name is Julio Jenner. I'm the architect for the project, and I also have the owner and present, and so is the tenant or the user of the project. We're in agreement with the conditions, and if there's any other questions regarding the construction or the proposed construction, I'd be happy to answer them for you.
Okay, Commissioner Brown has a question.
I really just have questions on the operation to get an
Okay.
understanding of that, so maybe
Yeah, I'll refer to that.
Good morning. My name is Karen Laver. I am the business owner and director of the Dance Network. Thank you so much for seeing us this morning, and I also would like to thank everyone who has helped us get this in front of you. They've been all really, really helpful, and we appreciate them very much.
Thank you. That's nice to hear. A question is on your hours of operation, 7 days a week, 3 to 10 p.m.
Yes.
So, like on Sunday night, you'll be there till 10 p.m.?
So it's generally an approximation, but the Sundays we tend to not go as late. But we figured generally we're there about 7 hours a day on any given day, depending on rehearsals. Again, classes and rehearsals are a little different. We put that we have classes most days from 7 to 10, but occasionally we will have an extra rehearsal or a private session, which doesn't impact the parking and the traffic in the same way.
Okay. And most of the students who come are brought by parents who just drop them off, or how does that work?
We actually, our students are ages 3 to 80, so we have multiple generations in the same the same family who come and dance, and a lot of times the families will come together and take classes together, especially with the multiple rooms in this new space. We would be able to offer classes for parents as well as children at the same time. So we would be able to promote carpooling. A lot of our dancers who are adults already will drive together. to classes. So we really do emphasize trying to reduce traffic impacts even in our current space.
Okay. The reason I asked that question is I was there at the shopping center on Saturday afternoon, and it was busy, bustling, lots of cars, not a lot of spaces. So that was my question, is just, you know, it doesn't seem to me that the number 5 spaces. I was just curious about how students got there and how I realize there's parking in the back and the rear.
Yeah. Well, the other, sorry to interrupt. Sorry. The other nice thing about being in this space is it's actually closer to a lot of our families. We have a number of families in the neighborhood.
Oh, they can walk.
They can walk, they can bike. There's a lot of plans to reduce the impact for parking.
Good. Well, thank you.
Yeah, you're welcome.
Thank you.
Any other questions?
That's it.
Okay,
Great.
thank you.
And I have a speaker slip here for Robert Dornan. I can't tell if that's you're the owner of the property, I guess. You're going to be speaking twice. I see 2 slips there. So the next item as well?
Next agenda item.
Gotcha.
Yeah. My name is Robert Dorn. I'm with Retail Opportunity Investments Corporation. We are the property owner. We acquired the property about 2 years ago. And just wanted to be here in person in case the commission has any questions for me.
Great. Thank you. Mr. Brown, you have questions?
No, I don't, but I just wanted to say that your improvements are very nice, and I think it's promoted a lot of people coming to the center too. So it'll be nice to see these new uses there.
Great. And I have one more speaker slip, Lisa Phelps.
Mr. Chair, Commissioners, thank you for the opportunity to speak. I'm here not necessarily to reiterate all
I could get you to grab the microphone a little closer, thanks.
Is that like that? Is that better?
Yeah, we did it on the record.
Okay. My name is Lisa Phelps, and I'm here to offer support for the current project. I'm also the person with whom you spoke, Commissioner Brown. Thank you. I'm also the person that wrote the letter I think that you were referring to. And I think this use would be very appropriate for the center. I think it would do a lot to help the center in terms of bringing in vitality and energy to the center. But when looking into this project, I think what I started to notice was that for dance schools and for dance studios in particular, which are a separate definition under the code, the allowable uses under the code largely restrict the ability for dance schools and dance studios to operate within the county. The dance studios especially, they're prohibited from operating in almost every zone, including C1, C2, C3, and SC. And they are only allowed to operate in CM, LA, PI, PICZ, and MU with a permit. So and I looked at the plans, and that doesn't really represent very much of the leasable space within the county. So we're sort of in a footloose situation where we've ended up restricting the ability of these businesses to operate. They are largely women-owned businesses, and I would be very interested in finding out if there was any support for looking into these zoning codes and looking at some of these school uses to see whether we can solve some of the issues that exist with our retail spaces in our community, which have been hit by Amazon and Walmart online and are having trouble finding retail businesses to come in. Would make sense to look at schools, particularly dance schools or martial arts schools, for example, to come in, operate within these spaces, create locally. These are locally owned businesses. They would fill in some of the blanks that we have. So if there were any support for that, I'd be very interested in helping out in any way I can.
Great, thank you. That's my last speaker slip. No one else come rising. So I'll bring it back to the staff. Do we have any comments to make after that?
Mr. Chair, no comments. Thank you.
Okay, I think we'll close the public hearing, bring it back to the commission for approval. And this is a second district item. Commissioner Brown.
Well, I would like to ask a question of Mr. Wilson, because I agree with Ms. Phelps that I think that the allowance for where schools, particularly dance schools, can be located it's sort of the same issue we had for cannabis. There's the zone districts, PI, and some of these other ones it's so restrictive that there's like no place to put them. So is there any thought about changing some of the allowances from the zoning tables in the near future? And if not,
Chair Blau, Commissioner Brown, in response to that question, staff did meet with Ms. Phelps and reviewed this particular topic. And this is a similar situation we've had on other instances in the ordinance. I think it came out on the process improvement workshop, potentially on signs as well, is that in order for a change to occur to the ordinance, it would need to be added to the work plan for long range planning to do an overhaul of the ordinance or to make some changes to the ordinance. Or another option is to have a member of the public submit an application for a zone code text amendment and to make changes that way, and then it can be processed. So those are the two avenues that we could pursue to change the ordinance. But as of right now, it isn't on the work plan, or it isn't scheduled to be there unless somebody wanted to bring it forward next year.
How does someone from the public make that request? Does it have to be attached to a project, or can be done separately, or making the text amendments?
So they can submit an application for zone code text amendment, and there's of course fees associated with that, and they would just be processed by staff, brought before the Planning Commission and ultimately the board for a decision. Okay. But it would be paid for by the member, the private citizen. The work plan, the commission is aware of how to move things forward on the work plan.
Right.
If the commission wanted to next year during the process of identifying items to be put on the work plan, that could be something that could be recommended to be added to the work plan and then reviewed through the budgetary process.
Okay. Thank you. Okay.
Thank you.
Okay.
There is one other method, but I'll tell you about it later.
Okay. Well, I'm greatly in support of this project. I think it will do everything that the speakers have indicated. While the center's got lots of vitality, I think it'll be nice to have this particular space filled. It's always sort of troubling to me to see that when there are these vacancies in these shopping centers. So I'm fully in support of it. I'm welcome them as a neighbor, so to speak, and look forward to seeing them. So I will move staff's recommendation to make the required findings for approval of the project and determine the project is exempt from CEQA and approve the project subject to the conditions with the change. We're going to make that one change for construction
hours.
Interior construction hours.
Right. Commissioner Park.
I wanted to say that this looks to me to be a really terrific community resource, and I think you should be proud of your school. I think that the diversity you have in age and styles of dance and ethnic background is just wonderful for this community. So I am disappointed in a couple ways. One, you didn't stage a dance demonstration, and you'll got to do that the next time. And but also too, I echo Ms. Phelps and Commissioner Brown's comments that this is a lot of work and stress for the property owner, for the school owner, staff, us, to be dealing with something that's really, folks, it's a no-brainer. And I want to say something for the property owner as well. I think this is good creative property management for shopping centers, because you have to kind of go in some different directions than what we used to do, grabbing chain stores. And so this is good all the way around. But I hope we can initiate some kind of process to do this. And we kind of have a balancing thing here, because we look at the long-range planning work assignments, okay, and we don't want to impose on that. On the other hand, do we really want more hearings like this where this whole apparatus takes the time? So all that being said, I do second the motion.
There we go. I was looking for that.
Thank you.
I will say, Mr. Wilson, if you could add an item to our workshop, which I believe end of October, and the item I'd like to add is how we can modify our procedures to make minor modifications to ordinances so it doesn't need to go through a long work plan. I mean, it's kind of like we're making a change to another one right now, and it's literally deleting a sentence from the code to create a problem that it was creating. This is simply adding some additional zonings that school could be into. That doesn't take a brain trust, and it shouldn't take more than about 10 or 15 minutes staff time to bring it back to us. So with that being said, Mr. Commissioner Brown, do you have other comments, or your light's still on?
Sorry,
No. Mr. Villalobos, I'll ask, do we have any further comments on the motion? I don't see any lights. You can call the roll, please.
Commissioner Park.
Aye.
Commissioner Cooney.
Aye.
Commissioner Farini.
Aye.
Commissioner Brown.
Aye.
Chair Blau.
Aye.
Motion passes 5-0.
Thank you very much. Now, if you'll read item number 2 into the record.
Thank you, Mr. Chair. The following is a hearing on the request of Jeremy Layton, agent for Goodland American Jiu-Jitsu, to consider case number 18 CUP 11, application filed on June 19, 2018, and to determine the project is exempt from the provisions of CEQA pursuant to state CEQA guidelines section 15301.
Thank you. And now we ex parte and site visits. We've already heard about the site visits. Mr. Brown.
No ex parte, but
Okay,
site visit.
great. Thank you very much. So, Ms. Reed, are you doing the second one as well?
Yes, I am.
All right, then let's have it.
Hi again, Mr. Chair, Commissioners. I promise this is not the same exact presentation. I'll go a little bit quicker because it is within the same shopping center. So this is the proposal for the Magnolia Shopping Center Martial Arts School, conditional use permit. Again, an aerial view of the shopping center. The proposed martial arts school will actually be located 3 doors down from the proposed dance school, or now approved dance school. The zoning for the shopping center is shopping center. Adjacent zoning is residential with 1 recreational area to the east. This is a close-up view of the 2,400 square foot subject lease area. No interior or exterior alterations are being proposed for this lease area. The proposed project complies with the Land Use and Development Code. Schools, businesses, professional or trade, and specifically a martial arts school isn't allowed use within the zone district. The project would comply with the shopping center zone's parking requirements. The proposed martial arts school would have a maximum of 12 students and 2 employees at a given time. So if we do the calculations, the martial arts school is required a minimum of 3 parking spaces. Again, the shopping center has a total of 576 parking spaces, so adequate parking is available to serve the proposed project. The project would also comply with the development standard regarding enclosure of activities, as the martial arts school would operate within the completely enclosed 2,400 square foot lease area. The proposed project is consistent with the comprehensive plan, the Eastern Goleta Valley Community Plan, and the revised development plan for the shopping center, approved in 2001. CEQA Guidelines Section 15301 applies to projects regarding existing structures. For this project, the notice of exemption was prepared, and staff concluded there will be no significant environmental effects, no significant cumulative impact, and no mitigation measures are necessary. Staff recommends that your commission make the required findings for approval of the project specified in Attachment A, including CEQA findings. Determine the project exempt from CEQA pursuant to CEQA Guidelines Section 15301, and approve the project 18 CUP 11 subject to the conditions included as Attachment B. This concludes my very quick presentation. I'm happy to answer any questions you may have.
Great, thank you. Mr. Brown.
I just have one question. The karate place, is that staying, or I'm not sure based upon the chart here, the graph?
Mr. Chair, Commissioner Brown, no, so the karate was a previously existing business.
And that's staying.
And it's no longer there.
Oh, it's no longer, okay.
Yes.
That's, okay, great, thank you.
Thank you very much. For any further questions, does the applicant want to approach the podium?
Good morning. I'm Julio Jen. I'm the architect for the project, and we are in agreement with the condition. It's on. Start over?
Yeah, go ahead. Yeah.
Good morning. I'm Julio Jen. I'm the architect for the project, and I'm representing the landlord here, and we have no issues with the conditions of approval.
Great, thank you.
Thank you.
Mr. Brown has a question.
So there's going to be no changes to the interior?
Actually, no, none whatsoever. But the user, the tenant is here. If you have any questions for the operations.
Oh, okay, so there's none. You're just going to.
Yeah.
Yes,
oh,
ma'am.
Cool. Good. Thank you.
Thank you. Mr. Dornan, do you have another speaker slip? Okay.
Again, my name is Robert Doran, Retail Opportunity Investment Corporation, owner of the property, and just wanted to be here to voice support of the project and answer any questions that the commissioners have.
Thank you.
And we also
did
have
the owner want to?
the operators here as well.
Well, we'd love to hear from him, so
Sure.
please come to the microphone. And actually, for applicants, I don't need speaker slips, but please put your name in the record, please.
My name is Jean-Paul Levonvie. Hello, everybody, and I'll answer any questions you like. The martial arts school is similar to wrestling and judo. We have students from all ages, not 80, but maybe 79, a bit closer. But we do all class privates and self-defense and more self-esteem building for youth and community. Kids with development issues or anger issues. I pretty much work with children, with parents, and helping them manage some of their deficiencies or some of their lack of managing their emotions. And school is small. We're not doing any physical work to it. It's just laying down mats and pretty much letting kids roll and adults do a wrestling program and a judo program, pretty much based around the jiu-jitsu.
Thank you.
I'll answer any questions you may have.
Thank you. Thank you very much.
You're welcome, sir.
I'm actually building a new building for that's kind of a deal in Santa Maria, and they're my tenant. I'm going to be your tenant for a month or two. Anyway, it's amazing to me how this business is increasing. I mean, since we put him into his new building, he's got 25% more students, and when he gets into the new, bigger building, it's going to be even bigger. So,
it's a really growing sport. The jiu-jitsu martial art itself will probably enter the U.S. Olympics probably in the next 8 years, as it will replace some of the other taekwondo sports events that they have in the Olympics. They will represent because they have judo already. So we're looking forward to represent, as a global martial art into our into the Olympic world class agenda and guidelines in the next 8 years.
Great.
I'm looking forward to that.
Thank you very much.
You're welcome, sir.
I have no other speaker slips. Does anybody else wish to approach the microphone? Okay, that'd be fine. Thank you.
Thank you so much.
Bring it back to the commission. This is, again, Second Item District. Commissioner Brown.
Well, I would just like to make some comments before I make the motion. Is what's nice, again, it's another lovely use of this space for the community, and I think that's just great. And what I like about this particular, where this activity is going to go, it's at the at the end, and what's nice is there are always a lot of empty parking spaces at that end of the building. So it works out really well, in my opinion, as a user of the shopping center anyway. So I think it's great, and it'll just, I don't know, it just adds something to the shopping center when you bring, a different range of people, ages, I think, and I think this project will also do that. So it's a really good use. So with that, I would just like to make the motion to make the required findings for approval of the project, determine the project is exempt from CEQA, and approve the project subject to conditions included in Attachment B.
Second.
Any further discussion on the motion? Commissioner Park.
I just want to make the same point that I think the operators should be proud of their operation. It's a great community resource. And make the obvious point, why are we subjecting these kind of community resources that do so many good things for children to the same scrutiny as marijuana dispensaries? It's beyond me.
Well, like I say, we're going to have our opportunity later in October to modify that. We'll get it changed. So, good. Seeing no other lights come on, Mr. Villalobos, will you read the roll call?
Commissioner Park.
Aye.
Commissioner Cooney.
Aye.
Commissioner Farini.
Aye.
Commissioner Brown.
Aye.
Chair Blau.
Aye.
Motion passes 5-0.
Okay. Let's go ahead. You want to take a break? We'll take a 5-minute break and set it for the next item. Thanks. Okay, we'll go back on the record. Mr. Villalobos, if we read item number 3 into the record.
Thank you, Mr. Chair. The following is a hearing on the request of the Jonata Ranchos Homeowners Association and joint appellants Whitney Scaling and North Buellton Hills Waterworks to consider case numbers 18 APL 16 and 17. Application filed on August 6, 2018 to appeal the director's approval of case number 18 HOM 17.
Thank you. I'm going to ask for ex parte or site visits. Not seeing Commissioner Park.
Yes. Yesterday I drove through the neighborhood and actually drove up to the house itself, up a driveway. And if the owner's here, I kind of apologize for that. I got lost and didn't ask your permission to drive up the driveway. So I guess I'm a trespasser, but at least I saw the place. And there you go.
Thank you. Ms. Reese, you're going to provide our staff report this morning. Thank you.
There we go. Thank you, Mr. Chair and Commissioners. Like Ms. Montano, I have two fairly similar presentations to give you. So the Powers land use permit for a homestay was for the use of 3 bedrooms of a 4-bedroom house in the Buellton area. And there were 2 appeals filed. So we'll be looking at the appeal issues from 2 different sets of appellants. And here's the vicinity map showing the proposed project site's proximity to Buellton and the Highway 101, and an aerial view of the proposed project site. And the subject parcel surrounded by similar residential uses, as well as a large agricultural parcel to the north of it, and that parcel is used for cattle grazing. And the subject parcel is located in the Bobcat Springs existing developed rural neighborhood, and it has 1E1 residential zoning. And homestays are an allowed use in residential zones with a land use permit and with conformity to the Land Use and Development Code development standards for homestays. The subject property was first used for a short-term rental in September of 2017, and this was prior to the board adoption of the related ordinance amendment. The property owner then submitted a homestay land use permit application in late July and received approval based upon the application's conformity with the Land Use and Development Code. 2 appeals were subsequently filed, and the first was by the Jonata Ranchos Homeowners Association. The second was a joint appeal by Whitney Scaling and the North Buellton Hills Waterworks Association.
So one thing to keep in mind here when considering the appeals is that the county does not approve or issue permits assuming that the permit recipient will violate the development standards from the Land Use and Development Code or the conditions of the permit. Our assumption is based that they will intend to comply, and if they don't, enforcement action is taken accordingly. So I'll begin with the Jonata Ranchos HOA appeal. And the first issue raised by those appellants was the contention that the property owner does not reside on site, and the appellant cited the mailing address that's on file with the assessor's office as evidence for that. And the appellant also contended that the submittal of misleading information was grounds for permit revocation. And so staff's response, the mailing address on file with the assessor's office has since been updated, but it's simply an address where income tax returns are sent to. And that the applicants also claim a homeowner's exemption on the property and did for the 2017 tax year as well. Additionally, the application materials and project description indicate 3 bedrooms for use with the homestay, which conforms to LUDC requirements. The applicant has also supplied some additional documentation regarding residency, including tax records, utility bills, bank statements, and vehicle registration, which is consistent with the conditions of approval for proof of residency. And lastly, the land use permit is not eligible for revocation at this stage because it has not yet been issued due to the appeal being filed. The second appeal issue was the contention that Ms. Powers is not listed as a property owner for the subject property, which would essentially make her not eligible to sign the permit application without agent authorization form. However, Mr. Kindervater and Ms. Powers are dual owners of the subject property, each with a 50% share, and they have been listed as dual owners since May 15th of 2017. So now to the second appellant case. This was by joint appellants Whitney Scaling and the North Buellton Hills Waterworks Association. The first appeal issue is that the owner has not complied with the owner occupancy requirement and cannot in the future. The appellants also contend that there's no indication that the applicant has ever resided or intends to reside at the subject property. Staff's response is that the tax records that were supplied provide some corroborating evidence that the property owners consider the subject property to be their primary residence. And as discussed previously, the applicants have also provided some additional documentation to that effect that's consistent with the project conditions and the application requirements. Additionally, it's worth noting that there was no owner occupancy requirement when the property owners began operating their short-term rental. This was prior to the grace period that was put in place by the Board of Supervisors for the operation of short-term rentals in the residential zones, and that ends on October 1st of this year, so coming up next Monday. And that grace period was essentially in order to give those operators that were conducting short-term rentals on a property in the residential zone some time to comply with the new ordinance amendment and obtain permits for a homestay if they were eligible. So therefore, the property owner has been compliant with board direction in the interim period. On to the second appeal issue. This one's rather long. The appellants contend that there has been no evaluation of short-term rentals on the surrounding community and that the homestay is not compatible with their neighborhood. The appellants are also contending that the homestay will adversely affect surrounding properties as well as nearby ag uses and the shared private services that they use. And the appellants are stating that the homestay approval changes the nature of the neighborhood from a residential community to that of commercial and retail uses. And to begin, the impacts of homestays on the residential zones in our community were extensively discussed and evaluated during the development of the short-term rental ordinance amendment through multiple staff reports, community meetings, hearings with both the Planning Commission and the Board of Supervisors. And the board had stated that the new development standards put in place by the ordinance would minimize the potential adverse impacts to surrounding areas. In response to the perceived impacts to agriculture, the board also found that short-term rental land uses are an incidental residential use to agriculture, and they're consistent with the definition of agriculture. To give you an idea of the agricultural uses near the property, the existing dwelling is approximately 300 feet from the adjacent parcel. There's a fenced property line that's shared, and that parcel is 138 acres used for cattle grazing. So there's really no conflict there as far as interfering with the use. Regarding utilities, there are adequate public and private services available to serve the existing single-family dwelling. There's no new development proposed with the permit. And the staff report does include the North Bealton Hills Waterworks Association contract. However, the county does not enforce private agreements like that governs the association. Any conflicts there would be a private dispute. However, that said, there doesn't seem to be any sort of clause in the contract that would exclude a homestay or rental use from service, and the utility costs and maintenance fees seem to be collected based on the quantity of water used. The third appeal issue relates to parking, and the appellants are contending that the parking is inadequate and the homestay should have as many as 7 spaces available. They're also contending that the applicant cannot comply with the parking requirements without materially changing the use of the subject property and making structural changes to the property and dwelling. So the single-family dwelling itself requires 2 parking spaces, and we are in the 1E1 zone district, and that does not require covered parking. It's allowed to be out in the open. With the configuration and size of the property, the applicant is able to provide 3 additional spaces, covering the requirement for 1 space per room of the homestay, and all of those spaces would meet the LUDC requirements for parking in a residential zone. Here's a diagram. We have the 2-car garage here that would cover any spaces for the single-family dwelling itself. And then we also have a paved area here, and all of that paved area is outside of the side and front yard setbacks and would not require cars to be parked in tandem. Hence, it meets the LUDC requirements for parking. The fourth appeal issue is a contention that the applicant has committed prior bad acts by advertising the rental on Airbnb and renting their property out as a short-term rental. But as we discussed previously, the STR was operated prior to board adoption of the short-term rental and homestay ordinance amendment, and the applicant is within their rights to operate a short-term rental until the end of the October 1st grace period. So in summary, the homestay LUP is compatible with residential zoning as well as the LUDC development standards, and it also meets all applicable LUDC, San Ynez Valley Community Plan, and Comprehensive Plan requirements. As far as environmental review goes, the CEQA guidelines section 15301 for existing facilities applies here, and that's because it covers the operation, permitting, and leasing of existing private structures that involve negligible or no expansion of use. And as stated before, the applicant has been utilizing the property as a 4-bedroom short-term rental. Hence, the proposed 3-bedroom homestay reduces the existing use, and therefore the project can be found exempt from CEQA. And staff recommends that the Planning Commission deny the appeals and make the required findings for denial of those appeals and determine that the project is exempt from CEQA. And that concludes, and to approve the project, subject to the conditions of approval included as attachment B. And that concludes my presentation. I believe both the applicant and the appellants are here and available for questions. And
thank you. Commissioner Brown.
Ms. Reese, could you put up that, I think it was your third slide that showed, it was like a Google aerial view of the home. Could you go back? Just wanted to, I think it was, did you have a closer up view? What I'm trying to get is a sense of how far this residence is to the next one. I know these are large properties, but was there?
I believe that the parcel immediately east of the property is the nearest residence.
So it's here. Can you just give me some orientation here? It's right down here.
Mm-hmm.
And where is the house located? Any idea? No, I know that, but the next property owner's house is down here somewhere.
There is, Mr. Chair, Commissioner Brown, there's another property immediately south of the project site. However, I believe it's located approximately 250 feet away.
Okay, so it's some distance. It's like the distance from the ag parcel then, 300 or 200 feet or so. Okay, thank you.
Any other questions from commissioners? Not seeing any. What I'm going to do next is ask the appellant to give him opportunity to approach the microphone. Then I'll be asking the applicant. Then I'll probably take public comment, and then you'll be able to do a rebuttal, and you'll be the applicant will be the last to speak. So.
Thank you, Mr. Chair, members of the commission. My name is Robert Forzonde, and although I initially submitted the appeal for Mr. Scaling and the Waterworks, I've been asked to speak on behalf of both appellants today. We received the staff's recommendations and the staff's report over the weekend. We appreciate the length and the extent of it. And had we gotten it earlier, we would have notified the board earlier that we're withdrawing our appeal. The reason being, based on the conditions of approval that were set forth in the staff's findings, most of our concerns have been alleviated. Namely, the 3 forms of verification of residency, the parking restriction, the appointment of a nuisance person to respond to nuisance issues, the annual renewal. Those have alleviated most of our concerns. And although we still continue to question how feasible it is for someone to occupy this type of residence while having 3 or more other adults there, we will defer to the verification process that county staff has taken. And with that being said, the appellants do want to note for the record that in light of the extensive revenue that the county will be deriving from short-term rentals from the tax revenue, that some of that money be put aside to at least perform more diligence in the permitting process, and also towards having an enforcement officer be dedicated to ensuring that the restrictions set forth on these permits are set through. So with that, we do withdraw our appeal based on the conditions of approval that have been recommended by staff for the permit.
Great, thank you very much.
Thank you.
Did the applicant wish to approach the microphone? Not seeing them. Mariah, oh, go ahead.
Sorry, I thought there was one more appellant. I had a presentation, but should we continue?
Well, if he's withdrawing the appeal, there's not much reason to do it. I think we're gonna. It sounds like we're gonna grant an approval for you after I take one speaker that I have. So.
Okay. Well, I want to thank the county and everyone for spending time on this. Thank you for visiting our property, and it happens all the time that people come up.
Okay.
So thank you.
I do have one speaker slip, and I think the last name is Gornan. Thank you. Close.
Hi, Jarrett Gorin, and I actually represent the next applicant, but I think it was important for me to speak on this item, representing my company, Vanguard Planning. We represent multiple applicants in the county, and we have no issues at all with this permit. We think you should approve the permit. I'm glad that the appellants withdrew, and for the reasons that they withdrew, that all makes great sense. Our concern is with the interchangeable use of required occupancy and required residency when short-term rental patrons are present. The county's ordinance doesn't require that one must occupy a homestay property as their principal place of residence. And all of these requirements and the conditions on both that permit, on the one I'm speaking to right now, are conditions to establish primary place of residence. For example, the homeowner's tax exemption, having to have utility bills from a year beforehand. None of these things are required by the adopted county ordinance. It says only that the owner or long-term tenant of the property shall inhabit the dwelling on the same lot at the same time as the transient occupant. So these additional requirements that have sort of cropped up like mushrooms, that you must also have this as your principal place of residence, those are not requirements of the county's ordinance, and I just wanted to make sure that was registered on this appeal. I would argue that you should approve this land use permit, but that you should delete that condition because that condition is inconsistent with what the Board of Supervisors adopted. And those are my comments.
Thank you. I have several other speakers, I believe, for the next item. Do I have any other speakers for this item? Commissioner Brown.
Mr. Chair, I wonder if we could get County Council's response to that speaker's.
Mr. Chair, Commissioner Brown, the LUDC does provide that the owner or long-term tenant shall inhabit a legal dwelling on the same lot at the same time as a transient occupant. Beyond that, we've been whispering at the table here. Perhaps it's something we could address on the next item, unless you have specific concerns for this
Well,
item.
I just was wondering about those specific items that the speaker talked about. Okay, fine, we'll wait.
And Jen, if you could help me with this, do we want to go ahead and deny the appeal and approve the project de novo, or do we just simply want to withdraw the appeal?
Mr. Chair, I would recommend, since during the appeal process conditions were added to the project, that your commission deny the appeal and grant de novo approval of the project. The appellant's stated withdrawal is based on these conditions being part of the project, whereas if the appeal is just withdrawn, it goes back to the original permit, which did not include all these conditions.
Okay, well, so knowing that the appeal was offered to be withdrawn based on the conditions that are approval, I think we do need to actually act on the appeal so that we can grant de novo approval. Commissioner Park, your lights on?
Yeah, I'll make a motion. It's in my district. I do want to make a few comments. For a number of reasons, I was on the fence on this project, but because it is being withdrawn, well, of course, it makes sense to go forward to deny the appeal. And I had some questions for the owner, but it's pointless at this point. So I do want to express a concern I have that's illuminated by this project. And that is, we need to be looking at road access to these. The Camino San Carlos, especially the upper reaches where you reach there, it's basically one car wide. And when we increase our occupancies with ADUs and then we add homestays, I think we need to be looking at that kind of thing. And that kind of thing to me is illustrated by this project. But we don't have an appeal. So what I'm going to do is move to deny the appeal.
Commissioner Park, Chair Blau. Before you make the motion, staff does have some changes to the recommended actions that were shown on the slide. So I'll let Shannon provide those recommended actions for the commission to consider.
Mr. Chair, Commissioner Park, just to clarify the record and the fourth recommendation, we are adding in is to grant de novo approval of the project, case number 18 HOM 17, subject to the conditions of approval included as attachment B to the staff report.
And I'll amend my motion to add that language.
Second.
We have a motion and a second. Any further discussion on that item? Not seeing any. I'm still a little concerned about the one speaker's comment. Do we need to clarify the condition so that it's consistent with the ordinance as provided by the board?
Chair Blau, members of the commission, it's within the commission's discretion to take action on this condition. This is, being that it's a condition of approval, the planning commission has discretion on to either remove it, modify it, or allow it. Being that it's a condition, it can be above or beyond what the ordinance requires. And so the reason that the condition is put on there, because there's been several interactions with staff or the department and the public on how to verify residency. And so this condition was placed on there to help staff evaluate or verify residency. Outside of that, there was only a signed affidavit that the applicant was going to have this in compliance with the ordinance. So those conditions, it helps clarify what verification of that residency is. And so staff's recommendation is to leave that condition on there, and it's within the commission's discretion to do that.
Mr. Brown.
Well, two questions. So when somebody applies, these three conditions or these three things are standards that they have to meet in an application, right?
No, I think what they're saying is that these are conditions that we're imposing now that was not, it was not imposed by the ordinance.
No, I understand, but to get the clarity that Mr. Wilson explained, that in the application, these are things that you ask for. Is that?
Chair Blau, Commissioner Brown, that is correct. Upon submittal, staff is requiring or requesting that the applicants provide additional sources of verification, and then it's added as a condition of approval just to validate that staff has reviewed it and they will be in compliant with that condition.
Okay. Then my other question, and this is probably County Counsel, and she may want me to wait for the next one, but these three items don't verify residency.
Mr. Chair, Commissioner Brown, in working with P&D, we had some trouble determining some document that would prove residency. I think these are,
but they don't prove residency. I can own multiple properties. I can say I've got 3 homes and I reside in each of them, but it doesn't just, anyway, I'll just wait till the next one. Okay. Thank you.
Okay. Thank you. I think we're ready for the question. Mr. Villalobos, would you call the roll?
Commissioner Park.
Aye.
Commissioner Cooney.
Aye.
Commissioner Farini.
Aye.
Commissioner Brown. Chair Blau.
Aye.
Motion passes 5-0.
Thank you. And we'll now read the last item into the record.
Thank you, Mr. Chair. The following is a hearing on the request of the joint appellants, Wanda Hesford and 15 other adjoining acres homeowners, to consider case number 18 APL 18 to appeal the director's approval of case number 18 HOM 19.
Commissioner Farini.
Ex parte.
Oh, ex parte and site visits. Yes, thank you.
And Theo Crack, the owner, did contact me yesterday, and I did speak with him.
Mr. Park.
I walked by the property on Monday and encountered the appellant who lives next door and the appellant's attorney and a neighbor. And my wife was there, and the neighbor's dogs were there, and my dog was there, and I can go on about who was all there. But anyway, that was an ex parte contact. I will disclose that I don't consider that I live in Janin Acres because I'm not part of that owners association, but I drive through it to get to my house, which is about 3/4 of a mile from the subject property. And so I do walk frequently past there and know the area very well.
So you're more than 500 feet from the property, am I correct?
Much more than 500 feet.
Yeah, okay. Just checking. Okay, Ms. Reese, I believe you're up.
Thank you, Mr. Chair. I'll try not to be too repetitive on this one, but this is a single appeal of the Cracky LUP application, again for 3 bedrooms of a homestay in a 4-bedroom house, and this is in the Solvang area, specifically Janin Acres. Here's a vicinity map showing the proposed project site's proximity to Highway 246 and the city of Solvang. And the subject parcel is located in Janin Acres, as I said, and is surrounded by similar residential uses. The subject parcel is located in the San Ynez urban area near the city of Solvang, and it is also zoned 1E1, a residential zone district. Again, homestays are an allowed use in the residential zones, given that a land use permit is acquired and there is conformity with the LUDC development standards. This subject property has been operating as a short-term rental in the past, and the owner applied for a homestay LUP in early August and received approval based on the application materials conformity with the LUDC development standards for homestays. And a joint appeal was subsequently filed by Ms. Hesford and I believe it was 16 other neighbors from Janin Acres. We were notified by the applicant or the appellant that was the case, contrary to the 15 read into the record. The first issue that was raised by the appellants was the contention that the property owner does not reside on site and that the applicant has provided misleading information to planning and development. The appellants also cited the Paradise Rentals webpage and the biography posted for Mr. Cracky, which mentions how long he's resided in Santa Barbara with his family. Additionally, the appellants submitted internet listings for the rentals, which indicate the availability of 4 bedrooms, and also mention that the entire home is available for rental. In staff's response, there was no owner occupancy requirement when the property owners began operating their short-term rental. And again, that's because of the grace period that was put in place by the board in order to give operators of short-term rentals in residential zones until October 1st of this year to bring their property into compliance with the new standards and to obtain permits for a homestay if eligible. So again, the owner has been compliant with board direction in the interim period. And the homestay LUP was approved based on its conformity with the application materials and also under the assumption of compliance with LUDC requirements. As I mentioned in the previous presentation, the county approves permits based on the assumption that people will be compliant with the conditions of approval, the project description, and the requirements that are in the Land Use and Development Code. The project description and the conditions of approval for this project require that the owner reside on site at the same time as transient occupants. And again, enforcement action could be taken if there wasn't residents at that same time as transient occupants. The second appeal issue was the contention that there's been a history of noise and traffic issues on the property, including loud parties that were exceeding the allowed number of guests and visitors, also overcrowded parking, noise issues after 10 p.m. And the appellants also contend that they would be required to record the homestay as a nuisance when selling their homes, and their property values would be affected by that homestay use adjacent to their properties. As discussed with the first appeal issue, there's a grace period in effect, and the owner has been within their right to operate a short-term rental at this time. And beginning October 1st, the number of guests, visitors, and bedrooms available would need to be limited in accordance with the development standards and the conditions of approval. Additionally, noise would also be limited further by the LUDC development standards because they're more stringent than the county code nighttime ordinance that currently applies to short-term rentals or any nighttime noise for that matter in the county. And
could I stop you there? My understanding is that the county requirement is 65 decibels at the property line. Do you say there is a more stringent noise for this particular property? As part of the go ahead. Mm-hmm.
Mr. Chair, the development standards state that from 10 p.m. to 8 a.m., the volume of sound generated by the homestay shall not exceed 45 decibels or existing ambient levels, whichever is greater, beyond the property boundary.
Thank you.
And we have not received any confirmed documentation of noise violations resulting from the existing short-term rental. The LUDC also requires homestay parking to be provided on site. And again, the single-family dwelling in the zone district requires 2 parking spaces, and the homestay use requires 1 space per bedroom. And there is a 4-car garage on the property, so the 2 single-family dwelling spaces could be placed within that, and 2 of the spaces for the homestay. Again, spaces aren't required to be covered, so the 3rd space for the homestay could be provided on the driveway outside of setbacks, as long as it didn't interfere or cause tandem parking to occur. So for that reason, there is 1 space per bedroom of the homestay already available. Regarding potential impacts to property value, the county does not regulate based on real estate disclosures or private property values, and the county also cannot verify whether the appellant's claims regarding disclosures of nuisances is accurate. And here's an aerial showing the available parking. We have the 4-car garage here, and also this space that's outside of the setbacks that would still allow the garage cars to not be tandem parked. In summary, the homestay LUP is compatible with residential zoning, and the project meets all applicable LUDC, San Ynez Valley Community Plan, and Comprehensive Plan requirements. And CEQA Guidelines Section 15301 also applies here because it covers operation, permitting, and leasing of existing private structures with no expansion or negligible expansion of use. Again, since this project or this property is currently being used as a 4-bedroom short-term rental, the homestay use in 3 bedrooms could be considered actually a reduction in use. So staff recommends that the Planning Commission deny the appeal, make the required findings for approval, determine that the project is exempt from CEQA, and approve the project subject to conditions of approval. And that concludes my presentation. I believe we've already heard from the agent for the applicant on this project, and we have a number of members of the joint appeal here as well.
Thank you. Commissioner Brown has a question.
Ms. Reese, would you put up that slide about parking availability again, please? So all the required parking can be contained in the garage, right? Is that what you're saying?
Mr. Chair, Ms. Brown, or Commissioner Brown, 1 additional space would actually be required on site, but it is possible for that to be accommodated in the driveway area without.
Can you show me where the driveway is?
Sure thing.
Can you show it where it connects with the street? Okay. And but they're allowed to have visitors, are they not? Chair Blau, Commissioner Brown, they are allowed to have 2 visitors per transient occupant that's an adult. Again, all parking for the homestay use does need to be provided on site here. Well, so is a parking allowed on the roadway, on these roadways?
Mr. Chair, Commissioner Brown, it is not.
Okay, thank you.
Commissioner Cooney.
Ms. Treese, I think before we get too far into this, we should clarify one point. A speaker for the prior item indicated that the ordinance adopted by the county does not require the owner of the property to be on the premises at the same time as the guests. And that's, as I recall, one of the crucial issues discussed as to whether homestays should be allowed at all. But our conditions do require that. So is there a difference between the condition and the language of the ordinance?
I'll take it. So Chair Blau, Commissioner Cooney, looking at the ordinance language under section 3542-193, subsection D1, it states the owner or long-term tenant of the property shall inhabit a legal dwelling on the same lot at the same time as a transient occupant of the homestay. And then under subsection 10, it talks about proof of ownership of long-term tenancy. The owner or long-term tenant of the property being rented for a homestay shall provide proof of ownership or long-term tenancy with the homestay applications. In addition, the owner must sign a permit application with the long-term tenant submits. So the ordinance requires proof of ownership. And one of what staff has presented today on the condition of approval is requiring residency, proof of residency, which is more restrictive than what the ordinance is. So the commission may review that condition, which is condition number 4 on the permit today, and determine whether or not it's applicable or appropriate for this project. One of the concerns that have come up and what staff has been evaluating is how to address the ownership and how to appropriately determine that the owner is occupying at the same time that it's being used as a homestay. So that's what the commission may discuss or present today to staff.
Well, I'm a little concerned. Obviously, the ordinance doesn't require the owner of the property to be residing there. It's either the owner resides there or a long-term tenant. So if we have a tenant with a year's lease for the 1-bedroom and common areas in the house, and we have 3 other temporary people in there, that complies with what the ordinance requires. I'm comfortable going beyond what the board approved and saying, no, we're not going to let the long-term tenant be one of the 4 bedrooms or 3 bedrooms. It's got to be the owner of the property. That's not what the ordinance requires.
That's why I just set it up.
Mr. Chair, condition number 4 allows or mentions both the owner or a long-term tenant. However, the application materials didn't include a signature for a long-term tenant. Additionally, a long-term tenant would be eligible to meet the requirement, provided that they had a longer than 6-month lease or minimum length 6-month lease residing on the property.
I'm just wondering if the additional conditions you're putting on there go beyond that. And what I don't want to have happen is, or maybe it's up to the commission to decide if we have the discretion, but I don't need the owner of the property coming back and amending his permit because he's not going to reside there and he puts a tenant in there that's got a 6-month or longer lease. Help us out, Jennifer. Jennifer, please.
Mr. Chair, Commission. So the project description proposed by the applicant here discusses the 4th bedroom being inhabited by the property owner. So I think we're relying on that assertion, and there's been no evidence that there is a long-term tenant. The applicant could modify their project description to say inhabited by the property owner or a long-term tenant if they want to keep that option open in the future. But I think staff has been relying on the applicant's proposed project, which just discusses a property owner living in the 4th bedroom.
Great. Thank you. So I think I'll go ahead and ask the appellant if they want to address the commission And then I'll ask for the applicant, and I'm going to ask the applicant if they want to modify their project description.
Good morning, Mr. Chairman, Commission. My name is Frank Blundo. I'm an attorney representing the appellants in this matter. And this discussion has kind of changed the approach regarding this appeal, because now I'm concerned about the fact that the term occupy appears to be in contradiction to the term inhabit, which is set forth in the ordinance. What does it mean to inhabit a dwelling? Does it mean you reside there? Does it mean you just have to be there when the short-term renters are there? I don't know the answer to that question, because now that it's just coming up. But I'm reminded of something that Supervisor Adams said at the time that the arguments were going on about short-term rentals. And his concern was that folks were going to get involved in creative evasion. That was his phrase. And I think that's what we have here. Because we have a situation where there's an applicant who is in the business of short-term rentals. That's what he does. He manages them, he advertises them. And he purchased this property in 2014 at the time when the property did have a restrictive covenant on it, which prohibited absolutely any business or commercial use. But that restrictive covenant expired in 2014 when the covenants were not renewed. So at the time he purchased the property, his intent all the time was to conduct a short-term rental. He renovated the property. He has never lived at the property. And as you've seen in the package, his life is in Santa Barbara. That's what he does. That's where he lives. That's where his kids are. That's where he runs his business. So the concern that we have is that the impact that this is going to have on the neighborhood, which will be demonstrated by the many folks over here today and in the materials that were submitted in the package, are profound. If there's any way we can put up that slide that shows the property itself, I'd like to point out one thing. Yes, that's the one. The rear of the property, if you'll note, the rear of the property, and perhaps
we're going to provide you a pointer. Could we provide him a pointer, please?
Thanks a lot. The rear of the property, and you notice the property is on a corner lot, but it's triangular. This area right here is what the neighborhood calls Disneyland. It's composed of a pool with a water slide and a fountain, a basketball court, a bocce court, horseshoes, and playground equipment. And the neighbor, Ms. Hesford, the original appellant, lives right here. This is her house. This is her yard. She is impacted constantly by the folks who are there in the current STR format. If this board were to say that the mere fact that the applicant might occupy a room without a bathroom, without a kitchen, without anything else, along with his homestay tenants, it's not going to change what happens at that property. There has been a constant and chronic noise issue and party issue at this property. Changing from 4 bedrooms to 3 bedrooms is not going to change that. Having perhaps the occupant or the applicant show up at 10 o'clock at night, sleep in this little 11 by 14 room, and then leave at 7 in the morning and then be gone all day is not going to solve the problem. And to to move forward and say, well, we can't do anything until after October 1 and after the problems arise, means then we have to get involved in attempts at enforcing violations. And I think it needs to be nipped in the bud. I think this needs further clarification and further verification that someone is actually going to be living there. Now, I know there were these additional conditions that were imposed by staff. I have not seen that there's been any compliance with those conditions. Maybe it's happened and I just haven't received it. But you know, whether or not there's a driver's license with this address, whether there's a homeowner's exemption. Last time I looked, there wasn't. Utility bills, I haven't seen any of that. So I don't know if the applicant's in compliance or not. What I do is I go back to what homestays were supposed to be. Homestays were supposed to be the widow, the single person, the person on a fixed income wants to rent out a bedroom, get the extra income in order to stay in their property. The couch surfing. That's what homestays were originally created for. They were not created, in my mind, and in the appellant's mind, for this purpose, which is strictly financial gain, profit. That's all this property is going to be used for. This is so far removed from what homestays were originally created or allowed to be created. So it's a real problem for all of our folks. I'm going to leave a few minutes for Ms. Hesford to speak. She's the most affected by this. I believe you also have materials that were submitted by several other folks in the neighborhood who are also here to speak. I think this appeal should be granted or at least delayed until the board can consider further the reality of whether this is a homestay, because we don't think it is. Thank you very much for your attention.
Thank you.
Good morning. My name is Lynn Hesford, and I reside directly next door to the Cracky Vacation Rental. My backyard backs up directly to their backyard, so any noise coming from the yard comes directly into my yard. I've lived here for 24 years, and until 4 years ago when Mr. Cracky bought the residence to put into his vacation rental pool, I've never had an issue with a neighbor or with noise. It's always been a quiet neighborhood, and everybody knows each other. I didn't sign up to live next door to a hotel, but that's exactly what has happened. Although I don't know what's going to happen going forward, Theo's short-term rental business has ruined my enjoyment of my home and neighborhood. Theo lists the property on his online rental sites as a vacation playground for prospective renters, and that's exactly what it is. They're here to party. I understand that it's normal on vacation, but this isn't a resort, it's a neighborhood. What's happened to me and my 16 other neighbors could happen in your neighborhood, and it could happen to your constituents. I've made numerous complaints to Paradise Rentals over the 4 years. They've been less and less responsive each time. And when Theo first came into the neighborhood, he went to all the neighbors and gave us a complaint line. And he asked us if there were any noise complaints to please call. And that's why there are no complaints on the record with the Sheriff's Department, because we called his complaint line. 24 hours a day, it's supposed to operate. But it's been less and less responsive. They don't return your calls. It goes to voicemail. I've had, they say, no, the renters aren't answering their phones. They can't get in contact with them. And that's because they're out partying and they can't hear their phones ringing. So some of the problems have been multiple families, multiple kids, and lots of screaming, outdoor pool, morning goes into the evening, early morning, well into the night. I've been woken up late at night by loud noises and screaming. I don't feel comfortable calling the sheriff because I live alone. When the sheriff, you complain about a neighbor, they know who's called them. I don't feel comfortable. I'd like to give you a couple examples of some of the more egregious things that have happened through the years. March 11th of this Saturday, my gardener was out working in my yard. And he came to me and said, the man next door told me I had to stop. And he's in my backyard. It's completely fenced. And so I said, what man? And he pointed, and there was a man hanging over my back fence. And I said, no, just ignore him. Do what you're doing. He was hedging, getting some garden stuff ready for spring. And he came back in a couple of minutes, and he said he wants to talk to you. So I went out, and I said, what can I help you with? And he said, the noise is ruining our party. He said, we're trying to enjoy the backyard. And I said, well, this is a neighborhood, and this is a Saturday, and this is what happens in neighborhoods on Saturday. And he said, you won't tell your gardener to stop? And I said, no. And he said, well, what if I call the sheriff? And I said, well, you can certainly do that. And he said, well, what are you going to do tonight when I make noise? And I said, well, then I'll call the sheriff. So, I mean, seriously, that's what happened. And he did, true to his word, they continued their party. My gardener did his work. They made noise late at night, but what am I supposed to do about it? Another day was also a Saturday. I was sitting outside on my patio. This was actually this past year. And I hear this, my dogs are going crazy, and I hear this weird noise, and I didn't know what it was. I looked up, and I figured out it was a drone. And it was hovering over my backyard, and I mean, it was really an invasion of privacy, and it was pretty darn scary for me. I had no idea where it came from. So I walked outside trying to see where it came from, and then I watched it land in the property next door, and it came back over, and so I went to the fence, and I said, hey guys, could you please not fly that over my yard? You're making me nervous. You're upsetting my dogs. They completely ignored me and just went on their way. That's what happens. That's really what happens in these rentals, and there's usually always lots and lots of people. It's not occupied by one family because it's very expensive. It's usually minimum of 4 families, all their kids. Another incident, I was out of town. I had a dog sitter there, and she said the dogs were going crazy. She went outside and found a bunch of people at the gate. And this was also the same week, the same renters that went up to a neighbor's property and were using their kids' playhouse and play equipment. But she went to the gate, and she had no clue who they were. And she said, "What can I help you with?" And she said, "We're just looking." And she said, "Well, do you know Lynn?" "No, I don't." She said, "Well, what are you doing?" She said, "We're just looking." And she said, "Well, I think you should go." It made her so uncomfortable, and she was staying in my house by herself, that she actually called her sister to ask her to come for the evening, to stay with her, spend the night. So that's the kind of thing that happens on a continuous basis in this residence. So it's just, and those are more out of the ordinary, but it's a constant party all the time. And it starts sometimes at 6 a.m., seriously, 6 a.m., with kids in the pool. I get it, it's vacation, but it's not the kind of thing that belongs in our neighborhood. So, thank you.
Thank you. Now I'll hear from the applicant.
Good afternoon, Mr. Chair. First of all, how much time do I have here? I'm not going to drone on and on. I just want to have some idea.
How much time do you need?
Probably less than 10 minutes.
That's fine. Go ahead.
Okay, so I'm Jarrett Gorin from Vanguard Planning, and I represent Theo and Becky Cracky, who own this property. And we've got an elected board of supervisors in this county. They represent everybody who lives in this county. They represent these appellants, and they also represent my clients. And our board of supervisors considered the entire question of homestays, and they adopted this homestay ordinance, which it allows for this use, as staff notes, as an incidental use to residential use. I think one of the foundational concepts in this appeal is that these appellants simply, they disagree with the Board of Supervisors that this is an incidental use in residential zones. And they have every right to disagree, but the county can't get into the business of approving or denying permits based on whether individual groups of neighbors agree or disagree with law that the Board of Supervisors has adopted. So in terms of the law, we've complied with it. Anything that's happened in the past, I have no reason to doubt these stories the appellant is telling. I mean, there's no way to verify them. Whether they, elected to call the sheriff or not was within their discretion. But if as they claim, my client was unresponsive, then the logical next step would have been to call the sheriff, and they certainly could have done that. There's no way to verify any of this, but again, I mean, I have no reason to doubt them. But anything that occurred in the past is not subject to this new ordinance. My client's applied for a permit under this new ordinance and intends to comply with the conditions of that permit. And that is also staff's assumption, that when an applicant comes in, that they intend to comply with the permit, and also that the information provided in that application is true and accurate. This appellant asks you to, based on their speculation about what may happen in the future, to deny a permit based on basically a website description that says my client enjoys living in Santa Barbara. There's nothing about his living in Santa Barbara that prevents him from being present in his homestay as required when transient occupants are present. I do have to clarify Commissioner Cooney's comments. I did not previously claim that the owner or tenant doesn't have to be present. I said that specifically that they must be present when transient occupants are present. My claim, and I'll get to it a little later, is they're not required to inhabit it as their principal place of residence. And that's sort of nuanced, but the difference is this where they live most of the time, or is it another residence that they own? And it comes up in discussions of accessory dwelling units and other things like that. But there is a legal distinction between principal place of residence and do you inhabit or not? And I believe the appellant's attorney is right to ask, what does inhabit mean? But I would argue that inhabit means you inhabit. You're there when the transient occupants are there, and that's what our adopted ordinance says. That individuals want to go beyond what the ordinance says is they can certainly ask for that, but I think we all need to acknowledge, as staff has, that these additional conditions are going beyond what the ordinance says. So just to address a couple of other things here, I don't think whether my client resides here permanently or not is a relevant issue at all. I would point out that my client says he has lived in the house 93 out of the 270 some odd days that are there. I know for a fact that he and his family go up there to enjoy the house in the summer and use the pool and all. And other times they have transient tenants there, and that was not subject to this ordinance. With a homestay, the appellants are arguing that with an owner or long-term tenant there, it doesn't make any difference. It's not going to make a difference. Well, I would argue the exact opposite. I would say that the intent of a homestay ordinance is to ensure that an owner or tenant is there when transient occupants are there expressly to affect their behavior. That's the point. Somebody is on site that owns the house to immediately respond to something like what the neighbors are describing, because they're present, and their job is there to, for lack of a better word, babysit the transient occupants. So there's a fundamental difference between a homestay and a regular short-term rental. As to some of these specifics on the parking, there is in fact a 4-car garage on the property. So there's actually one space per each of the rooms, but this is proposed as a 3-bedroom homestay, with the 4th bedroom being occupied by the owner or a long-term tenant when transient occupants are present. And again, this challenge based on previous listings as a 4-bedroom really is not germane to our application, which is to use this as a 3-bedroom. A past listing that has nothing to do with our proposal really, I'm not sure why that's evidence in support of this appeal in any way. The road access, I'll address that. I wasn't thinking about that, but it came up on the previous one. There's excellent road access here. There's at least 2 separate ways into and out of the property for emergency access or occupant access. So there's great road access. There's plenty of parking. Commissioner Brown was speaking about guests and guest parking. And I need to make clear that a residential house doesn't have a guest parking requirement. It has a requirement to provide 2 parking spaces on site for its residents, and there's no conditions that bar me as a homeowner from having a dinner party or a party and having other people that park in the street. And there's no conditions in the county's adopted homestay ordinance that require for provision of guest parking on site for the guests of homestay occupants or transient occupants. And I really don't think we want to get into a situation where the county can only approve homestays if they've literally have an on-site parking lot in anticipation of guests that transient occupants might have. The Board of Supervisors and staff and everybody who participated in the hearings during the adoption of this ordinance put a lot of thought into this and decided what to include and not include as requirements of this ordinance. Ultimately, we have what was adopted, and ultimately we have what my client has proposed, which is consistent with what was adopted, as noted by staff, that our application meets all of the criteria. So we believe you should follow staff's recommendation and deny this appeal. I want to address these conditions in item 4. One of the interesting things that just came up is staff saying that you need to have a long-term tenancy is defined by it's more than 6 months. Okay, well, one of the requirements that they're asking you to impose is on this project is to require that we provide a utility bill from 1 year prior to and within the last month of an application date. Well, how does that work? If it's okay to have a long-term tenant that is on a 6-month lease, but we can't have a permit unless we're providing utility bills from 1 year prior, those things are those are just inconsistent. There's no way to do it if you have a 6-month tenant. So it's really problematic. Also, on the homeowner's tax exemption, the owner's required to be present when transient occupants are present. They're not required to use the homestay as their principal place of residence. And the Board of Supervisors, they could have required that when they adopted this ordinance. There was nothing at all that prevented our Board of Supervisors from making the requirement that you must have it as your principal place of residence. They didn't do that. And I would assert there's a reason they didn't do that. And who knows, they could do that in the future with an amendment. But the ordinance right now as it stands and what you're evaluating this project against, it doesn't require this to be the principal place of residence. And condition 4 as proposed basically does require that. You know, in terms of proving ownership, we have no issue with that. There's plenty of ways to prove ownership, and we're more than happy to prove that, and we're more than happy to prove that in absence of ownership, the owner living there, that we have a long-term tenant present. And I also would ask that you amend our project description to say the owner or a long-term tenant. But those are, you know, you're going to see a lot of neighbors coming forward every time you see a homestay application and making identical claims that these neighbors are making, because nobody wants it in their neighborhood. But our county doesn't make decisions based on what little groups of individual neighbors say. They make decisions for the community as a whole. The community as a whole elects our Board of Supervisors, and our Board of Supervisors has determined this is an appropriate use for a single-family residential neighborhood like Janin Acres. And, you know, I really hope that things in the future go better than they have in the past. And I think that having an owner on site or a long-term tenant on site consistent with this ordinance, I believe it's really going to help with that. But if it doesn't, the county has enforcement. They can revoke this permit, and the neighbors have, you know, if the client isn't responsive for some reason, call the sheriff. That's the next step. So I don't think it would be prudent to deny this permit based on speculation about future events. And that's what I have to say, and I can answer any questions you have.
Great. I don't think we have any questions right now, but I'm going to ask for public comment. We'll go back to the applicant, the appellate, and give you a chance to respond at the very end. First one I have is Lisa Cox.
Chairman Bell, I did have a question of the
go ahead.
Applicant's representative. I noticed on the websites that the applicant operates other properties in the valley. Is that right?
Mr. Chair, Commissioner Park, my client operates a short-term rental business and has properties everywhere. This is his property.
Well, that's what I was going to ask. Does he actually own any of the other properties in the San Ynez Valley?
Mr. Chair, Commissioner Park, I don't know if he owns other properties in the San Ynez Valley. As far as I know, this is the only other property he owns in that area.
Well, do you know if he claims to inhabit any of the other properties that his business operates in the San Ynez Valley?
Mr. Chair, Commissioner Park, I don't know if he claims to occupy any of the other properties he owns.
Okay. Can I ask staff that same question? Because if you look at Paradise Rentals, there's several other San Ynez properties, and I don't know who owns them. You can't tell from the website, but I wonder if they are owned and if they also have paperwork here in the county that shows that this owner says that he is, or certifies that he also inhabits those properties.
Mr. Chair, Commissioner Park, I did look into this. There have been no other homestay applications filed by Mr. Cracky for which he is listed as the owner.
And Mr. Chair, Commissioner Park, I do know of other properties that he operates, and I do know that those are owned by others, other applicants that live there as well.
Thank you. First speaker is Lisa Cox. Fine. No, you know what? I'll allow that. Just tell me what your name is when you're up there, and I'll pull the slips out as you speak.
Good morning, Mr. Chair and Commissioners. My name is Amy Grenier. My family and I live at 226 Sunrise Way. We've owned this home for 12 years. Although have only lived in it full-time in the last 4 years. We used to live in Los Angeles. Our property is at the end of Sunrise Way. It's around that curve. We're about 4 or 5 lots away from the Cracky rental property. Like my neighbors and co-appellants who you will hear from today, I'm deeply upset by the damage that Mr. Cracky's rental business has caused to our quiet, wonderful residential neighborhood. Mr. Cracky does not live here in this home. I don't believe he intends to comply with the requirements of living in that home. He is not our neighbor. I know all my neighbors. Even when I wasn't living full-time at the house, I knew all of my neighbors, from walking dogs in the neighborhood, from going to neighborhood parties. It's hard for me to imagine that Mr. Cracky has spent a third or more of the year in that home. I've never met him in the 4 years he's owned the house. According to Mr. Cracky's own biography on his vacation rental business website, he has been a resident of Santa Barbara since 1981. He has deep ties in the Santa Barbara community. He and his wife own and live in a beautiful 4-bedroom large home on the Mesa with their 2 children. They've lived in that home for 16 years. Mr. Cracky and his wife have 2 children in private middle and elementary schools in Santa Barbara. His wife coaches his daughter's softball team in Santa Barbara. He and his family, by their social media postings, also clearly enjoy much time together in Santa Barbara. He owns a boat at Santa Barbara Yacht Club. They do many activities in the area. So given all of this, does it seem likely that a 55-year-old dedicated family man is going to leave his wife, his children, his nice 4-bedroom home to go and live with complete strangers in a house? He's going to occupy an 11 by 14 bedroom, share a bathroom, a kitchen, a laundry room, the backyard with total strangers. Equally impossible for us to imagine is that these total strangers are going to sign up to pay $900 or more per night to live in a house with a man they don't know and share the kitchen, a third bathroom, laundry, etc. with this strange man. His rental prices haven't gone down. I also want to tell you that looking on his Airbnb calendar the other day for the dates between October 1st and December 31st, he's got 31 of the 90 days booked off for rentals, including the weeks of Thanksgiving and Christmas. It is hard for us to imagine that he's going to leave his family to hang out with strangers during Christmas and Thanksgiving, and that we will be able to have access to him should those families renting the home continue to party there like they have in the past. I'd also like to point out to the Commission that he does not comply, as of today, with all the conditions of approval. All 3 of Mr. Crackey's rental website listings continue to include a description of the home as a 4-bedroom home. That includes the bedroom he's supposed to be living in.
I need you to kind of conclude.
I'm almost done. And there's absolutely no mention on the listings that someone will be living in the home at the same time as the renters. In light of these comments, I would really encourage you to either stay the appeal and do some further investigation, or consider additional conditions which require at least a minimum number of hours for owners or tenants to be at the house, so we can prevent the types of abuse that you've heard about today.
Thank you.
Thank you.
Mm-hmm. The next speaker.
First off, I have to apologize. I'm going to play the little old lady card. I checked the wrong box. My name is Elaine Ravel, and I am opposed to the homestay, but I'm in favor of the appeal. I've lived in my house since 1965, 53 years a week from this Saturday. I live...
You need to stay at the microphone, please.
Okay. There's no red button. I don't know what I did. Oh. Put that back up. Yeah, please do. Okay. My house is right here. I'm just one driveway from Lynn. I have been impacted by the noise. I'm used to hearing the missiles go off, and one morning before 8 o'clock, I thought that's what it was. It turned out it was the deep bass on somebody's boom box, or whatever they call them these days, and it was rattling my windows. So in discussion later that morning, found out we did have a number to call. I called, got an answering machine, called the second 24-hour guaranteed, got an answering machine, and said that if I had to make a third call, I would call the sheriff. 15 minutes later, it was off. However, I left for the day, and I've got here, which I won't go into, record of a texting that went on between Lynn and this Mr. Crackey, who I have never met either, that this continued throughout the day. They'd call, it would shut down. Finally, the messages were ignored, and the latest one on there was that there'd be additional people arriving that afternoon. And one of my big concerns are the roads. We have elderly people, I mean older than I, who've lived there older than I, that have mobility problems, and they walk in the late afternoon, early morning, and I don't know if you can tell how wide that road is. But I took some photographs one day, and there's 11 cars parked in the driveway, 4, I guess, in the garage, and 3 along the road. Now, contrary to what this fine gentleman here said, we don't have 2 ways in and 2 ways out. There are 2 roads off of 246, but every single one of our roads ends in a cul-de-sac. And when you've got people parked on the shoulders and halfway into the road, and they're pointing away from our exits, and should we have an emergency situation, they don't even know where to go. They don't know where to go.
Thank you.
That's it.
Good.
I apologize, and thank you for listening to us.
Thank you.
Deeply
Next speaker,
concerned.
please.
Ma'am, you said you have to be on the mic.
Go ahead. You are?
Thank you to the Santa Barbara Planning Commissioners for allowing me and my neighbors to speak about our sincere concerns regarding Mr. Cracky's homestay application. My name is Eileen Thornton Karras, and I live at 2289 Sunrise Way. My husband and I purchased our retirement home just 1 year ago. We looked for 10 months for a home in the San Ynez Valley and decided quickly, very quickly, within 2 or 3 months, that we wanted to be in Janet Acres for 3 specific reasons. The first one was the solitude that the area provided. Excuse me. The second was the lack of road traffic in and out of the community. And the third was the comfort of knowing our neighbors in the community in close proximity to our home. Mr. Cracky's homestay takes away all of those wonderful benefits to living in Janet Acres. In fact, as has been reported, Mr. Cracky's resort-like backyard with the pool and a water slide and the hot tub and the outdoor kitchen and the horseshoe pit, all of that, and combined with a continuous string of strangers coming in and out of the home every weekend or every week, the house becomes a party house. And generally speaking, with a party house, you have excessive noise, which we've made note of at all hours of the day and night. You have additional traffic. You have additional cars in and out of the neighborhood. And you have renters who generally are not that concerned about the neighborhood. They're concerned about their vacation, which I understand, but they're not really concerned about the hours that they're having their parties or the general concern for the neighbors at large. Additionally, I think, as a soon-to-be grandmother, that strangers coming and going in our neighborhood has the potential of an added threat to the residents of the neighborhood. I think for all of us, our primary concern is the peacefulness of our neighborhood. But we also know that having a homestay just 2 homes away from my property, and certainly much closer for some others, has the potential to seriously reduce the value of our home. I believe that Mr. Cracky will not reside at the home. And even if there is a long-term tenant residing in the home, I still believe that the same concerns of noise, traffic, streams of strangers in and out will continue to disrupt our neighborhood. It's my belief that a single-family residential neighborhood should be exactly that. A residential neighborhood only, and no home in the neighborhood should violate that with streams of renters coming in and out week after week. We care deeply about this issue. Some of our neighbors could not be here today, but their statements are included in the appeal, and some cite very specific unpleasant incidents with the renters in this house. It's disheartening to me and my neighbors that one person's desire to run a very lucrative business that negatively impacts the residents in that neighborhood should be more important than the concerns of the entire community at large.
Thank you.
Thank you very much for listening.
Good morning. Hopefully it's still morning. My name is Jamie Edlin. I live at 2269 Sunrise Way, around the corner from the Cracky property. I don't really have anything new to say. Everything's been covered. I think that it's impossible to imagine that Mr. Cracky is going to be leaving his home in Santa Barbara and moving up to this rental property, what we call a party house, on the holidays, just to comply with whatever rules. I find it really hard to believe. My home is distant enough from the Cracky property to not be affected immediately by noise, but I'm over at Lynn's house or I'm walking my dogs and I hear the noise, I hear the splashing, I hear the bands, and I see the cars lined up on the side of the street. They are not all contained within the driveway. They come and they go. There was an incident a few weeks ago that looked like there was a big party going on there. The cars were lined up. They were in the driveway. There were beach balls. As Lynn said at the beginning, it's like a hotel. It's like a small hotel there. And it just has no place in a quiet, peaceful residential neighborhood. I just moved there 6.5 years ago, having left LA. One of the many reasons why I left LA is because living in the Hollywood Hills, there were a lot of what we call party houses. People are paying a lot of money to rent these homes for the weekend, and they're going to get their money's worth. There's pools, there's basketball courts, there's tennis courts, etc. We moved, it also tremendously affected our property value. We had to disclose that this was a nuisance property next to ours, and that affected the sale of our house and what we got on our house. We moved to this quiet, peaceful neighborhood, Sunrise Way, Jannon Acres, and we have the same situation. We have a party house, and it just has no place in this neighborhood. Thank you for listening to us.
Thank you.
Good morning. My name is Lisa Cox, and I live at 2267 Sunrise Way, which is, for about 5 years now, we built our home and couldn't be happier with where we live and our neighbors. We live around the corner from, next door to Jamie here, are not directly affected by what was being discussed today, but I can tell you this. The idea that there are strangers living in a neighborhood where there is the kind of camaraderie we have has been very distressing for myself and actually all of our neighbors directly next door to me. We feel it's inappropriate to have an Airbnb in 1 acre lots. I can understand in San Ynez Valley there's 15, 20 acres where there is a separate home where the owner lives there and can observe what's going on, but this just seems inappropriate. Again, I have not met Theo, don't even know what he looks like, and considering we walk by there every day walking our dog, that's kind of unusual. And I feel like that if he is living there, then he could maybe help us with some of the issues that have been discussed today, but I think it's quite clear that that's not the case. So we are just, as a group, trying to ask for your help in this situation, and we're not going to be able to change what you decide on, but I think it's enough that you can understand why we are upset about this, and hopefully we can resolve it. Thank you.
Thank you.
Good morning. Is this my time? Okay. Thank you for hearing me. My name is Michelle Henricks. I moved to the San Ynez Valley 30 years ago. I purchased a home here on Sunrise next to this property 4 years ago, and I am impacted by the noise. My house, you can't see it from here, but it's directly across the tree line and a direct line of sight to this house, and the noise travels there. And the particular part that's disturbing to me is I work all week long, and on the weekend I like to sit out in my backyard and read a book and relax and enjoy myself. And all I'm hearing is parties. It's like I was living next door to a hotel. It's just not appropriate for our neighborhood. And there are cars parked on the street. The people that are staying there, they come and then they invite all kinds of friends to their party, and they're parking on that street. And as everyone says, we have elderly people that live in our neighborhood. They've been there for almost 50 years, or maybe in some cases longer. And some of them have Parkinson's, and they're walking on the street with walkers. And we all walk our dogs on the street. We have younger families that have moved in and have children and babies in carriages. And I was just watching the other day a mother pushing her child in a little stroller, and her other child was riding a miniature horse down the street. We don't have sidewalks. We have to use the street. And it's very dangerous for all of these cars coming in. And the problem is the people that come and rent the house are not like neighbors. You can have a neighbor that has a party. Well, you know your neighbor, and they let you know they're going to have a party. They usually invite you to their party just so that you know that you don't get upset. But they're not. These are people that transients that they don't give a darn about the rest of the neighbors and what's going on there, and so the party, the parking, the fact that there's nobody living in the house that is a neighbor. There are these people that are coming like a hotel. There isn't even a manager on the property, like you would at Meadowlark Motel or something. It's just the people come and go, and they get a key, and they do what they want. And I don't believe Mr. Cracky's going to come in or even have a long-term rental in a bedroom that's going to share with people. I mean, I know the Board of Supervisors passed this rule, but I think it's ridiculous. You guys ought to help them change it. So thank you very much for hearing for me. I hope you vote in our favor for the appeal. Thank you.
Thank you. I have 2 slips left. Amy and Catherine.
Oh, I'm Amy Webb.
Hi, I'm Catherine Hansen. I live at 2300 Sunrise Way. I'm just the second house on the left-hand side, more or less opposite Lynn's. I agree with all the points made by my fellow neighbours, and I'm just concerned at the pattern of problems at this property. The biggest thing is it's a quiet neighbourhood, and the noise level is just, at times is crazy. And just to go back on one thing, Lynn had a party in her garden, and we went down. It was about 12 of us, and we were sitting outside, but the property was rented next door, and with the noise and the shouting from the pool with the kids and the adults, we actually had to move into Lynn's house so we could talk. Also, Elaine had mentioned the morning of the loud music. This was at 7:30 in the morning. It was rude, it was just inconsiderate, not acceptable. So I'm just concerned that the county has no way of monitoring the rental to make sure it's a homestay and that these problems, will keep occurring. Okay, thank you.
Thank you. And Amy, you already spoke? Okay, great. So that's the last of my speaker slips. We're good to go? Okay. I'll bring it back and ask the appellant if they want to address the commission again.
Thank you. Frank Blundo again for the appellant. Chairman, board. I took the liberty of checking the definition of inhabit while we were waiting, and it's defined as to occupy as a place of settled residence. That seems to me to imply that that's your primary residence. The other thing that I'd like to mention, I'm not going to repeat what the other appellant said. Even though the county does not enforce private agreements between neighbors in a homeowners association and such, the county could still end up being a party for a civil code claim for nuisance that these neighbors could bring against that homeowner. If after October 1, if this board grants him his permit, he continues on the same path that he's been on. And there's no reason to think he won't. Because the reality is the way this property is marketed and the way it's described, it invites people to treat it as a party house. You're allowed, under the new terms, 6 people, because 2 people per bedroom, plus children, plus twice the amount of adults for guests. So we're looking at potentially a total of 18 people, plus children, who could be there at any one time. That's a lot of people. And if they're all in the backyard, they're using the outdoor kitchen, they're in the pool, they have this water slide that makes a lot of noise when the fountain's turned on. They're throwing horseshoes, which are right against Lynn's fence, by the way, so she hears the clank. The bocce court. There's so much going on, and this house is really made for outdoor activity. That's really the purpose of it. The indoor is not so much. It's the outdoor, and that's what sells. So we really would request that that this commission take a real hard look at this and deny this this application now until at least you have further information that makes everyone comfortable that there's going to be compliance. Thank you.
Thank you.
Mr. Chair, members of the commission, wow, an attorney threatening you with a lawsuit if you don't uphold their appeal.
Yeah, we're used to it. Don't worry about it.
Okay, so, well, I would also say that the county also requires applicants to sign an indemnification agreement now. So, you know, in the event they did decide to enjoin you in a suit, my client would have to pay for your defense. So that's a new thing you've been doing, but that's the case if you've got any fears about that. As to the party house claims, it's important that we understand here that the homestay is a new use. Everything we've heard about is what's happened, and a homestay is a new use. There are new regulations that are applicable to this permit that didn't exist during the time that the neighbors are describing here. Again, you know, when we write ordinances, we don't just do it off the cuff. We think hard about them. We get a lot of input about them, and the Board of Supervisors adopted very specific occupancy requirements for homestays. And again, I believe they had a reason for picking the occupancy requirements they did. And in coming up with this ordinance, all of the requirements that you see in this ordinance are geared towards addressing these very concerns. I wouldn't say for a minute that, you know, nobody on the Board of Supervisors, you know, thought these types of things might happen with homestays. They obviously did, and these are the requirements that they adopted. And this is a new permit. These are new requirements. My clients are obligated to comply with the requirements of this permit. If they don't comply, this permit can and it should be revoked if they're out of compliance. And that is, I think, that is the comfort the neighbors should have, is that you can revoke this. What's inappropriate would be to, based on speculation about how somebody's going to behave, to not issue a permit that they've complied with all the requirements and they meet the requirements for. You know, the DMV can't deny me a driver's license because they think I'm going to speed. If I do enough times, they can take it away. And that's how permits like this work. In terms of this Christmas and Thanksgiving thing, it's my clients who've booked the house for Christmas and Thanksgiving. They intend to spend those holidays at the house. So they booked it so that anybody else would know it wasn't available during those times. That's most of what I have to say. You know, on inhabit, you know, I'm sure if I go on Google, I can find other definitions of inhabit as well. I think, you know, the Board of Supervisors had every opportunity to require that one use a homestay as their principal place of residence. I think the appellant's attorney would agree with me that that's a far better definition if that's what the board's intent was. And whether or not that was their intent, that's not what's codified in your ordinance. So those are my responses to what I heard, and I can answer any other questions that you might have.
I'm not seeing any questions, so thank you. Does staff have any comment? No, it doesn't. Okay, this is 3rd District again. How would you like to proceed, Commissioner Park?
I have a specific motion I want to make, but I want to explain how I got there, because this has been a very difficult one for me to reason through. It really has, for a lot of reasons. So let me explain my reasoning. First of all, I'm not a clairvoyant, but I know what everybody to the left of me is thinking. You're all thinking, boy, I'm glad this was in the 3rd district and not my district.
Got that right.
Okay? And my retort to that thought of yours that you're not expressing is that, well, guess what? We're probably going to see homestay appeals on every agenda for the next several years, unless this ordinance is changed. And you're going to see them for Orcutt, and you're going to see them for Lake Marie, and you're going to see them for West Goleta, and you're going to see them all over Montecito. So get ready. It'll be your turn. And why do I say that? Not just to be silly, but to make the point that we need to be deadly serious about this, because how we act today on homestay appeals is going to give a signal on how we act on all the others. In analyzing that, you know my litany. I always say we're here to serve the public, we're here to be practical, and we're here to be independent. And I think of how to apply those principles. There's a lot to look at. I think the owner here is a fascinating person. I'd like to meet him someday. I would. I think he's done, but I think he's done some interesting things. I think he's built up a very impressive business. He's a UCSB alum. He's been a lot more successful than I was, and he's younger, so he must be really something. But I got to say, I admire him for that. The property is impeccably maintained. Does a great job maintaining it. There is a lot of parking there. And I do agree with the applicant's representative that probably every homestay is going to get some neighborhood opposition. But I think that as much as I admire the owner, I admire the neighbors who have come to speak up. And I think they could all say, well, and probably every homestay owner is going to try and do what Mr. Crackey's doing here in terms of claiming how they inhabit it. So we have to face those things. I would also agree with the applicant's representative that a lot of what we've heard today that are complaints about the property they aren't directly addressed in the development standards or the standards that are set forth in the ordinance. They just aren't there. So how do we look at that? Well, I think we need to look at the ordinance. If we look at the Powers Homestay Appeal staff report, you can see a quote from our staff that says LUDC section 3542-193A, which is sort of the introductory portion of the ordinance, states that, quote, the purpose and intent of this section is to establish standards that will regulate the use of dwellings as homestays in order to ensure that homestays are compatible with and do not adversely impact surrounding properties. Okay? Now, there's kind of a hole in the ordinance because there's not a whole lot in the standards that carries that out. I guess one could say, well, by designating zones where these are possible, we do that. But you know, that's kind of obvious. I mean, they're in residential zones, they're going to be in residential zones. So kind of duh. I mean, that doesn't really implement this clear intent of the Board of Supervisors. Can we ignore that language because there are no standards that necessarily carry it out? No. For 40 years, I've been litigating the meaning and interpretation of constitutional provisions, statutes, ordinances, regulations, trust documents, contracts. You have it. And one of the cardinal rules of construction is that you look at every word in a document or an ordinance and you try to give it meaning when you interpret it. Otherwise, why would it be there? And I think that the board intended that we do look at compatibility and with how it would adversely impact surrounding properties. I'm not going to recite all the testimony that you've already heard from both sides. I would point out some concerns I have there. If you walk through that neighborhood, it is a parade of elderly people, and please no one make funny remarks about what I look like, but it's a parade of elderly people walking their dogs and doing things, and that's something to think about as people come in and out on this homestay. But also, that neighborhood has about 3 miles of roads that only access, there's only one point of access. They only access Highway 246 through one spot. They go through the intersection of Jannon Way and Entrance Road. So in a fire, an earthquake, somebody trying to get Santa Ynez Cottage Hospital emergency room, whatever, it's all through there. This concerns me when we are talking about ADUs that are going to pop up, Can't do anything about that, but when we have a plan like this where you can have multiple people, I think we do have to take that into account. And we do have to take into account neighborhood compatibility. We've been given that discretion. There has to be discretion to do something besides just check the box and see if somebody has a driver's license. So I think our discretion includes looking at compatibility with a neighborhood, and I have grave concerns about the compatibility of this with this neighborhood. There may be other neighborhoods where they would be compatible, not necessarily here. More direct concern is the requirement that the owner inhabit the property. I do think there are some holes in this ordinance. There's some ambiguities, but that doesn't mean we have to ignore it. It clearly says inhabit, and I believe that the words inhabit here really mean two things. They got to live there, and you got to be there. You got to be there when the transient's there, and you got to live there. Okay, that's what I think it means, and I think that's what the board means, and that's what I think the board contemplated. I don't think they contemplated when they passed this and used the words inhabit that what the applicant plans to do complied. I don't think so. You know, I'm mindful of court hearings I've been in where, in fact, I can remember to this day Judge Ron Stevens, who passed away decades ago, but I can remember this, where he looked at something somebody certified, and after they testified, he said, you know, I'm going to refer this to the district attorney for perjury. And I noticed that our certification requirement is basically doesn't use the word certify properly. And I hear the word affidavit, and that's not the legal definition of an affidavit. An affidavit is a signed document under penalty of perjury. In fact, we use affidavits where there is a notary notarizes a document, or we have certifications under penalty of perjury. That's a declaration, but it's all under penalty of perjury, so that when you say something, there's a legal consequence to not stating the truth. And that's something I think that homestay applicants have to look at here. So I am not convinced that there is that the inhabitation requirement's been met. I don't know what standard of evidence we would use here. It's not really stated in the ordinance. Using the least rigorous one, preponderance of the evidence, I think there has not been proof of the preponderance of the evidence that there is inhabitation by the owner here. I think there has been proof by preponderance of the evidence that the owner won't be inhabiting this, and so I'm going to move to grant the appeal.
I'll second that.
Okay, we have a motion and a second. Before we go on, Ms. Richardson, you have a comment for us.
Mr. Chair and Commissioners, since the package in front of you is to deny the appeal and grant de novo approval of the project, if the Commission wants to approve the appeal and deny the project, I'd recommend providing that direction to staff, and then staff would return at a later hearing with the findings and support for that action.
So moved.
Just for your benefit, Mr. Wilson, that's another thing you can add to our process improvement. I don't like the idea that, I mean, for me, it's really pretty simple. You're saying based on incompatibility with the neighborhood, that's why you want to grant, you want to grant the appeal. That is the finding as far as I'm concerned. I really don't understand why we have to come back and redo this again. It seems to me to be a kind of a waste of energy, waste of time, and waste of money. Having said that, I'll just make comment. One of the things that we wrestled with and I argued for at great length when we looked at the short-term rentals was to not try and take a sledgehammer to the issue, but rather a scalpel. Seems to me, and what I've heard today and what I heard for all the time we dealt with that, was the noise. I don't get it. I got to tell you the truth. If I sit here and just be quiet, that's 45 decibels right there. That's just the air conditioner running is 45 decibels. Why we can't give our sheriff a decibel meter, one that acts very accurately, and when there is a complaint, you do call the sheriff. He walks out to the property line, tests the noise. If it exceeds 65 decibels during the day or 45 decibels at night, he issues the property owner a fine. First fine $500, second fine $500, third fine $1,000, fourth fine $2,000. I can guarantee you that the property owners that were doing the short-term rentals would take measures to make sure that you're not bothered by the noise. And I think we could do the same thing with the car parking. I'm going to support your motion to uphold the appeal, simply because I think the applicant needs to take this to the board if they want to continue, and let the board wrestle with some of the poor wording or the in my opinion, the lack of addressing the real issue that's the problem. And the real problem is the noise, I think. The wild partying and so forth. I get that. But no, I'm sorry, you can't. We've closed the public hearing, so so I guess I'm not going to argue with County Council today. I'll argue with them later on the process improvement as to how we handle these votes in the future. But so, Commissioner Brown, do you want to weigh in?
Yes, I do. When we heard the short-term, when we heard the homestay ordinance, I guess this was last year. I really don't recall, but it was very difficult for this commission. We heard many homeowners who had been affected by short-term rentals at the podium, just much as you've come today to tell us of the problems. And it was very difficult in crafting the ordinance and in dealing with the issues. And I guess I'm really deeply disappointed that we didn't get it right, that we didn't get the details right. Very difficult probably to do that because we didn't have any familiarity with this. We depended upon other jurisdictions and what they were doing and how they were crafting their ordinances. So we just kind of didn't get there. But I think that we need to get there to ensure that there is greater compatibility and there are standards for that, so that this kind of issue doesn't keep coming back again and again and again, because I have a fear that it will. And I think for me, because I'm a neighborhood person, I'm one of these elderly persons that walks their 3 dogs in my neighborhood. I know what goes on in my neighborhood and I don't have to put up with this, but I don't think it was the intent of the board that neighbors would have to put up with this kind of activity. So I'm, as I said, I'm in support of your concerns and your issues. I support the coming back for upholding the appeal with the findings, and I think we just need to do a better job. So if it goes to the board, hopefully there'll be some action that they can take to speed up getting the regulations with more detail to address some of these issues.
Mr. Cooney.
Well, I'm going to pile on, but I want to make a couple of points for the benefit of Mr. Blund. First of all, I think it was a big mistake to threaten the board with civil action, which is how I interpreted it. The problem is, you know, we are volunteers, basically. We're trying to sort out a complicated conflict of where, if ever, people should be allowed to rent their homes. You know, we wouldn't be here today if one of your neighbors who wasn't renting it out had this same house with all those basketball hoops and noise-making equipment out in the backyard and just chose to ignore what his or her neighbors felt about it. But we are here because of an attempt by the county to permit a narrow use of property that otherwise was unclear could be used. And we started with the short-term rental, and we argued about it and argued about it. I think we had 8 hearings before the Planning Commission just on the short-term rental. And believe me, the opposition was not from just a couple of landowners. We had lines and lines of people who plan weddings, who believe the San Ynez Valley is the place to send their clients for rental purposes, and a lot of people saw it as a money-making proposition and argued to the county, you guys will make a lot of money as well because these people will be paying permit fees, and all of that, I believe, we pushed back against and rejected. But the remnant that survived was this homestay and the farmstay, which is related to a different use property. And I don't believe for a minute that the board intended this to be another form of short-term rental. I think they wanted to somehow control the use so that both the homeowner could use their property for some other purpose, thinking of a single person whose spouse had no longer lived there, and this is a way to make some income with the guest house or whatever. But clearly, it was not intended as another way of describing a short-term rental. And Supervisor Adam was quoted in this hearing as having warned against the creative use of exemptions. My problem is, in coming in, I emotionally agreed with exactly what Commissioner Park has proposed, but my feeling was legally we were forced to rely on the provisions of our ordinance that call for revocation of a permit once it's violated. This is not something that is revocation of a conditional use permit, which requires the Planning Commission to intervene. It's described in these conditions, Condition 9, that the director may do it upon a finding that any of these conditions, any one of these conditions is violated, including the residency requirement, which would mean an aggrieved homeowner, neighbor, would be able to go into our planning and development department and provide evidence, preferably an enforcement person would have a report, and we wouldn't have to wait a year. Not only would the Cracky's permit not be renewed, but it would be within the director's discretion to that very month revoke the permit. And I think the board had that in mind, that if we have good homestays and compliant owners and they're there and they control the action, they'd be allowed to continue. But if they don't, if what people predict would be just an extension here of the Cracky's current use of the property as a short-term rental, that would not continue. And I think that's the appropriate way for the county to address this, is after the fact, as staff has said. I like Commissioner Park's suggestion that we take the bull by the horns, interpret the ordinance in a way that gives us an upfront finding of incompatibility, and I'll support it. But personally, I think the system and the legal background we have here would require us to wait until the permit is in effect and then look at revoking it for all the reasons everybody's cited. Thank you.
Commissioner Freeney.
Thank you. Wow, well, really great comments by fellow commissioners, and also I think a great job by staff. I would agree initially in reading the staff report and looking at everything that I agree with the staff report and the direction that they have asked us to take. Then what is a neighborhood? And so we heard from the neighbors, and the neighbors aren't happy, and I don't think it doesn't sound like they've been placated at all, or that they can be at this point. I still am not sure that this is the proper venue for us to go down, is just kick it out of here on a denial. So I'm really, really struggling with it. If my neighbors came to me with these complaints, because I live in the neighborhood and I live with them, I would want to improve my standing in the neighborhood with my neighbors. And I think that is a big part of the issue here, is if you don't live there, or if you're not at least regularly appearing and interacting with your neighborhood and your neighbors, we create this type of problem. And as Commissioner Park said, we're going to see a lot of this, and I don't think any of us want to see a lot of this. We don't want to see a lot of neighborhood incompatibility. We don't want to see 8 neighbors coming in and having to hire an attorney so that they can have some peace and quiet. I don't believe the Board of Supervisors' intention was for a homestay to be a party place every weekend, and I wouldn't want to have parties next to me every weekend. I did raise a lot of kids. I'm kind of equally guilty of kind of having a Disneyland in the backyard where kids make a lot of noise. But there again, I've never had a complaint. So it's different because we live there. So I don't know. I really don't know which way to vote on this. But I think in this instance, because of the discussion made by all of the commissioners, I will go with the majority here.
Yeah. One last thing I want to bring up. One of the ordinance needs to be, an issue needs to be addressed. I could foresee the property owner renting 1 bedroom to, let's call it a caretaker for 6 months or a year at $900 a night, if that's the rental rate. I could put that long-term tenant in there for free, and he could be like almost like a property manager. Maybe does a little cleaning and checks people in and checks people out, and that's clearly not the intent, I don't think, of the board. If it was, they need to let us know that. I think they were trying to do something different than that. So, you know, it's a mess. It needs some work, and I think we can try and convey that to the board. You know, it's something I think we should convey to the board. I'll particularly tell my supervisor that I think it's a problem that needs to be relooked at. I would hope the rest of you would do the same. Commissioner Park.
Just a very quick, I emphasize quick, point of clarification. One on Mr. Blendo's comments about potential litigation for nuisance. That litigation would be against the owner, not against the county. If he was going to sue the county, that would be a threat of mandamus. So I do not believe that Mr. Blendo threatened to sue the county. I want to be very clear about that. I think he just said that there's a potential civil action that could occur even if whatever occurred with what we did. Now, as to the findings, I appreciate what other commissioners have said about compatibility with the neighborhood, and perhaps I should have put my comments in a different order. My primary point is that I do not feel that the applicant has demonstrated that the applicant does and will inhabit the property as required by the statute. So I do expect to see that in any findings, okay? Aside from any mention of compatibility issues. Thank you.
Okay, and so I'm about ready to call for the question. I just need to point out that that's not what the ordinance says, so that's my concern. If I were to put a tenant in there on a 6-month lease, I comply with the ordinance. There isn't a requirement in the ordinance for the owner to occupy it. It's just that he has to have somebody occupy it full time that's a tenant. He can be the owner, he can be a tenant. So I'd be surprised if the county council can come back with the findings as you described them, because I don't think that's a correct finding. But it doesn't matter. They'll come back with the findings to uphold the appeal later on. Any further comment? Not seeing any. Mr. Wilson, yes.
Just a matter of clarification for Commissioner Park and through the chair is when you make the motion formally that we pick a date to come back. And I, talking with staff, they're saying they could return on October 31st or November 7th.
In all fairness to the applicant, I think we should do it October 31st. It's a consent item kind of a thing. And that way, if he chooses to appeal it to the board, it'll happen quicker than later. I hate to deny him the opportunity. So, does that sound fair to you? Okay. So we pick the date. Does the second agree? The second agrees. Okay, let's have a roll call.
Commissioner Brown? Commissioner Farini?
Aye.
Commissioner Cooney?
Aye.
Commissioner Park?
Aye.
And Chair Blau?
See, I see you went backwards. You threw us out of that. Tricky, very nice.
They're going to be unsettled all day now.
That's it. Okay, do we have any further business? Well, we figured out we couldn't use the room in Santa Maria, so we're meeting here again on that other deal. That's fine.
Get some clarity. So we're meeting next on October 3rd? No. Yes?
No, we're not.
No. So
we canceled the October 3rd hearing.
Okay.
Next time we're meeting is October 31st.
Okay.
Happy Halloween.
Chair Blau, members of the commission, I believe that you took a motion earlier to cancel the meeting on the 3rd.
Right.
And correct. To have that item placed on the November 7th.
That's
date. Correct. And
but we'll take this one on the 31st.
And the item that we just heard will be on the 31st.
Correct.
Right. Okay.
And then just a matter of clarification, I will work with David Villalobos or hearing support staff. If the room becomes available on November 7th, then we could potentially move the 7th to Santa Maria. At this time, it's already scheduled for another meeting at that time.
We prefer that. Hopefully they can move the other meeting. I really would like to have the hoop structure occur in the North County, since that's where most of the hoop structures are going to be located. But
yep.
So hopefully you can work that out. Okay, I believe that's it. Meeting's adjourned.